Do you need a trust? I get asked this all the time from clients. What they're really saying to me is, do I have to have a trust in order for my assets to not go through probate when I pass away? So probate is a court process where a list of your assets, called an inventory, has to be submitted to a judge, and creditors can make claims against those assets. And a lot of paperwork has to be done and gone back and forth between the court system and your attorney before the judge can finally say, okay, all the bills that needed to be paid were paid, and everything that's left can either go to the beneficiaries if the person had a last will and testament, or to the heirs, the people who rightfully inherit your assets under Florida law. This process is often lengthy and expensive. So it's typically number one, or if not number one, number two on the list of things people want to accomplish when they're putting together an estate plan. And what I mean by that is they want to avoid probate. That's something that they want to accomplish. So do you have to have a trust to avoid probate? So the short answer to this is no. You don't have to have a trust to avoid probate. There are other ways to avoid probate. One, you can own assets jointly, which is seen most often when you have a spouse and your spouse owns the home with you, or both spouses are on a bank account, brokerage account, something of that nature. So jointly owned assets pass directly to the survivor of whoever you're owning it with when one person passes away. Now, the issue with this is after one person passes away, like say one spouse passes away and you just have a surviving spouse, you no longer have a jointly owned asset. So when the survivor passes away, bingo, probate. So really not a perfect system. Option number two is you can make sure you have beneficiaries, or TODs, transfer on death, or PODs, payable on death, designations on everything you own. So this is typical on bank accounts. Bank accounts will often allow you to list a POD, or sometimes they'll do an ITF account in trust for. Other assets that allow TOD designations depending on what state you're in. Some states allow TODs for vehicles or other types of instruments. Oftentimes we can list beneficiaries on life insurance, retirement accounts, brokerage accounts. So there's all sorts of ways to list beneficiaries on things that you own. And in fact, in Florida, we're one of only 5 states who allows you to utilize what's called a ladybird deed to list one or more beneficiaries on any real property. So you can essentially, most of the time, be able to avoid probate simply by listing beneficiaries on everything that you own. This is possible. In fact, in Florida, you're even permitted to have a transfer on death or TOD provision in corporate bylaws or an LLC operating agreement, which as a method to actually pass a business down to someone and to hopefully avoid probate. Is this a perfect system? No. And what I mean by that is when you list a beneficiary, there's no guarantee, one, that the beneficiary won't pass away before you. So then you have an asset that will, again, be subject to probate. Or if they're listed amongst other beneficiaries, their portion is going to have to go through probate. Or there's a chance a beneficiary could become disabled, and inheriting something outright like a bank account or a brokerage account or real property could put them in jeopardy of losing very important government benefits like Medicaid if they're on it. So this is where we look at, do I need a trust? So really the trust is the only way to get 100% peace of mind, meaning you can cover any eventuality under a trust, and you can say in the trust agreement what is going to happen in any specific instance in order to make sure that if something does come up out of the ordinary, it's covered and the asset still stays out of probate. Now, a trust is simply an agreement between you as the person who's creating the trust and usually you as the trustee as to what's going to happen to your assets while you're alive, after you pass away. It's just a detailed plan on everything that you want to have happen to your assets, along with what the trustee, again, you typically while you're alive or someone else after you pass away, what they're permitted to do, what they can't do, what they should do. So there's certain ground rules for that as well. But what this agreement can also cover, for example, is if someone passes away before me, then where does their share go? If they're getting a certain percentage of what I own, but they die first, does it go to their kids? We commonly see the terms per stirpes. That's what that means. Is it going to their children? Is it going to someone else entirely? Is it going to a charity? So the trust can handle that. So it avoids probate that might otherwise happen on a beneficiary designation if that beneficiary passes away before you. Also, if a beneficiary becomes disabled, you can have a language within the trust that allows a special needs trust to be created for that individual so they can still inherit and have someone manage their funds, a trustee of their trust, so that things can still be bought for them during their lifetime and they can still benefit. And then you can also name a beneficiary of, if anything's left over in their percentage, a beneficiary who would get that after they pass away. So these are just a couple examples of issues that trusts can fix that plain beneficiary designations cannot. Now, everyone's different. I run into situations all the time where people only have a couple of accounts, maybe a much older couple with young, healthy children or a young, healthy child. They're not super stressed or concerned about a beneficiary passing away before them or becoming disabled. So in this instance, we may simply allow them to keep the beneficiary designations they already have, and recommend a ladybird deed for any real property as a way to cover all their assets so they don't go through probate. So each scenario is a little bit different. Several factors are going to play into it. Age, are there minor children? Because minor children also, there's issues listing them as beneficiaries because it's not easy for them to just inherit money when they're minors. So age, do you have minor children? What are you trying to accomplish? Are charities involved? These are all things, though, that you should discuss with a qualified estate planning attorney or elder law attorney where you live, because it's really important to know the benefits, the pros and the cons of any planning, and to know exactly what's going to be the right fit for you. All right, so if you like this video, please hit the like button on it. And if you are in Florida and you have additional questions about estate planning or elder law, Medicaid, please don't hesitate to reach out to our office. We're atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.